for legal legals exclusively. Part 3. Polish Restructuring Law. Selected articles. Article 36. Debtors' information duties towards the arrangement supervisor. 1. Conclusion of an agreement with the arrangement supervisor does not restrict the debtor's administration powers over its assets. 2. The debtor provides the arrangement supervisor with full and true information to be used in the restructuring proceedings and makes available documents that concern its assets and liabilities. 3. The debtor provides the arrangement supervisor with the information referred to in Section 2 under pain of incurring criminal liability for providing false information to be used in the restructuring proceedings and for suppressing information which is material for conducting the restructuring proceedings, and the arrangement supervisor informs the debtor thereof. 4. The arrangement supervisor is not liable for the veracity of the information provided by the debtor who is informed of criminal liability, which is referred to in Section 3. This, however, does not waive the arrangement supervisor's duty to duly verify the information provided, in particular if there are reasonable doubts as to whether the information is true. Article 119. Acceptance of the arrangement. 1. The resolution of the creditors' meeting on the acceptance of the arrangement is made if the majority of the voting creditors who have cast a valid vote and who hold jointly at least 2/3 of the total amount of receivables vested in the voting creditors vote in favor of the resolution. 2. If the vote on the arrangement is held in groups of creditors comprising individual categories of interests. The arrangement is adopted if, in each group, the majority of voting creditors who hold jointly at least 2/3 of the total amount of receivable vested in the voting creditors vote in favor of the resolution. 3. The arrangement is accepted even without receiving the required majority of votes in some of the groups of creditors if the creditors who jointly hold 2/3 of the total amount of receivables vested in the voting creditors have voted for accepting the arrangement, and the creditors of the group or groups who have voted against the acceptance of the arrangement will be satisfied under the arrangement to a degree not less beneficial than if bankruptcy proceedings were conducted. Article 212. Collection of votes. After having determined the arrangement day, the debtor collects the votes in writing by presenting the creditors with ballot cards. Article 249. Fiduciary agreements, proper application of regulations. The provisions of this Act, which concern a pledge and receivables secured with a pledge, apply accordingly to objects subject to an agreement, transferring ownership of a thing, a receivable or other right, which was concluded to secure the receivable, and an agreement stipulating retention of ownership of the thing sold for the benefit of the seller and of the receivables secured with a pledge. Article 252. Prohibition of rendering performances from receivables subject to the arrangement. 1. As of the day of opening accelerated arrangement proceedings until the day of their closing, or the day on which the decision to discontinue the accelerated arrangement proceedings becomes final and unappealable, the debtor or the arrangement supervisor may not render performances from the receivables which by operation of law are subject to the arrangement. 2. In order to render performance of liabilities under a contractual compensation clause, which is referred to in the Act of the 2nd of April 2004 on certain financial securities, the provisions of Section 1 do not apply if, subsection 1, The financial security, including supplementary security, has been established to take account of fluctuations in the value of the object of security or the value of secured financial receivables, or subsection 2, cash, credit receivables, or financial instruments have been withdrawn as security in return for replacement or exchange of such security on the day of opening accelerated arrangement proceedings, but before the decision to open the proceedings has been issued. Article 253. Conditions of admissibility to mutually offset receivables. 1. As of the day of opening accelerated arrangement proceedings and until the day of their closing, or the day on which the decision to discontinue the accelerated arrangement proceedings becomes final and unappealable, the offsetting of mutual receivables between the debtor and the creditor is not allowed. If the creditor, subsection 1, has become the debtor's debtor after the day of opening accelerated arrangement proceedings, subsection 2, while being the debtor's debtor, has become the debtor's creditor after the day of opening accelerated arrangement proceedings through acquisition by way of an assignment or endorsement of the receivable arising before the day of opening the accelerated arrangement proceedings. 2. The offsetting of mutual receivables is allowed if the receivables were acquired through repayment of debt for which the acquiring party was personally liable, or through repayment made with certain asset constituents, and if the acquiring party's liability for the debt arose before the day of filing an application to open accelerated arrangement proceedings. 3. The creditor wishing to use the right to offset the receivables pursuant to Section 2 must submit a statement to this effect to the debtor, and if the debtor has no power of administration, to the administrator, not later than within 30 days from the day of opening accelerated arrangement proceedings, and if the basis for offsetting arose at a later date, within 30 days from the day upon which the basis for offsetting arose. The statement is effective also if filed with the court supervisor. Article 256. Prohibition of terminating lease agreements with the right to collect benefits or not. 1. As of the day of opening accelerated arrangement proceedings and until the day of their closing, or the day upon which the decision to discontinue the accelerated arrangement proceedings becomes final and unappealable, the lessor, with the right to collect benefits or not, may not give notice of termination of a lease agreement, with the right to collect benefits or not, of premises or real property where the debtor's business operates, without having previously obtained the consent of the creditors' committee. 2. The provisions of Section 1 apply accordingly to credit agreements concerning financial resources made available to the borrower before the day of opening proceedings, leasing agreements, property insurance agreements, bank account agreements, surety agreements, agreements covering licenses granted to the debtor, and guarantees or letters of credit issued before the day of opening the arrangement proceedings. The provisions of Sections 1 and 2 do not apply if the basis for terminating the agreement is the debtor's failure to perform, after the day of opening arrangement proceedings, liabilities which are not subject to the arrangement or other circumstance stipulated in the agreement if they occur after the day of opening the proceedings. Article 260. 1. A creditor holding a receivable secured on the debtor's assets with a mortgage, pledge, registered pledge, tax lien, or maritime mortgage may, in the course of accelerated arrangement proceedings, carry out enforcement solely from the object of security. End of Part 3. Thank you. For legal legals exclusively.